Borrowing and raising money. A business will often need extra capital to fund its activities. There are two main sources of capital for a business: debt capital, which is money borrowed from a lender, and equity capital, which is money provided by an investor in the business who becomes an owner of the business. In this short video, we will consider each of these two sources of capital. Firstly, debt capital. Debt capital is money that is borrowed by a business from a lender. The business will have a contract with the lender, and if the business defaults, the lender will be entitled to sue them for breach of contract. This means that the rules we considered in topics 5 and 6 of this subject relating to the formation and enforcement of contracts will be relevant here. The loan that is made to the business may be unsecured, which means that the lender relies solely upon the borrower's promise to repay the debt as set out in the loan contract, or secured. If it is a secured loan, the lender, otherwise known as the secured creditor, will be entitled to seize and sell the property over which the loan is secured in the event that the business defaults. The security property may be real property, in other words land or an interest in land, or personal property. A mortgage is a security for a loan over real property. To be enforceable against third parties, the mortgage must be registered. If it is unregistered, the mortgage will only be enforceable against the borrower. In the event of a default, the lender or mortgagee has a number of legal remedies available to them. The lender could enforce the terms of the loan contract, in other words, sue the borrower for breaching the contract. The lender could take possession of the security property. Where this is real property, this means that the lender will move into or occupy the real property, or if the real property is being leased to a tenant, the lender will enter into receipt of the rental payments. The lender could appoint a receiver. This will be a useful remedy when the security property is being used by the borrower as the premises for a business. The lender could foreclose. This means that the lender will become the owner of the security property. And finally, the lender could exercise power of sale. This means that the lender sells the security property in order to recover some or all of the money that's owing to them. The lender is under a legal obligation to take all reasonable steps to receive market value for the security property. If when they sell the security property there isn't enough money recovered in order to repay the loan, then the borrower will still owe the balance as a personal debt. If the lender sells the security property and receives more than the value of the outstanding balance of the loan, then any extra amount has to be repaid to the borrower. Charges over personal property, such as motor vehicles, furniture, or equipment as security for a loan, are regulated by the Personal Property Securities Act of 2009. The Personal Property Securities Register allows lenders to register their charges over personal property on a single national register. A failure to register a charge on the PPS register will not prevent the lender enforcing the charge against the borrower, but it will result in the charge being unenforceable against third parties. The second source of capital available to a business is equity capital. Since an investor becomes an owner of the business, investment in a business has important legal consequences depending upon the legal structure of the business. If the business is a sole trader, only the sole trader can invest in a business. If somebody else wants to join the sole trader as an owner of the business, then the sole trader will cease to be a sole trader, and the original owner and the investor will become partners in a new partnership. Similarly, if the business is already a partnership, then the investor will join that partnership as a new partner. As we saw earlier, sole traders and partners have unlimited personal liability for the debts of the business. It's therefore quite difficult to persuade somebody to join a partnership and to assume unlimited personal liability. It's much easier to attract investment in a company, which is why when we talk about equity capital, we focus upon share capital. A company's share capital is the amount of money or assets contributed by shareholders when they subscribe for shares in the company. When a company is formed, a certain number of shares are issued to the initial shareholders. The company also has the option of later deciding to raise more money by increasing the number of issued shares. There is considerable scope for people investing in companies to be misled or deceived, which is why companies and people who are setting up companies who wish to sell their shares to members of the public are required to comply with fairly rigorous legal rules set out in the Corporations Act. Generally, a company must provide investors with a prospectus containing detailed information about the company and the shares before the investors decide to subscribe for those shares, unless the issue falls within one of the exemptions set out in the Act. Any person who suffers loss or damage as a result of a defective disclosure statement, i.e., because of a misleading or deceptive or incorrect statement within the prospectus, is entitled to sue the company for damages.